I'm Mary Irvin and I'm a member of the education team at the ITA. I'm delighted to present this month's webinar, Ask the Experts, the Anti-Doping Rule Violations, alongside our panellist Ayesha Talpade, the ITA's Senior Legal Counsel, and my colleague. Ayesha, a massive welcome to today's webinar. Thank you for joining us.
Thank you, Mary, and hello to everybody who's joining us from across the world.
Yeah, we've had so many messages in the chat already. I'm seeing not only good afternoons for us here in Switzerland, but also plenty of people saying good morning and even good night as well. So no matter what your time zone is, thank you so much for joining us. Well, to get the most out of today's webinar, we are offering translation in Arabic, French, Russian and Spanish. We also have some captions in English, and just to note that we are recording the session. We are going to tackle many of the questions you submitted in advance, so thank you for that. And we're also going to leave some time at the end to answer any additional questions live. So that's just a little reminder that you can write a question in the Q&A box at any time during the webinar, but really the earlier you write your question, the better. And I would also ask you to please remember to keep your question on today's topic, which is the anti-doping rule violations. That way we get the most out of the next 60 minutes with our legal expert, Ayesha. And Ayesha, it was 18 months ago that we last did a legal webinar, so we don't get you here all the time. So really important that we keep these questions legally focused. Now, before we do tackle these topics, we do want to also say that today's webinar is not binding legal or professional advice. If you are notified or feel you may have committed an anti-doping rule violation, please consult a legal professional who can give you advice tailor-made to your situation. Now, we often find that when we ask the question, what is doping? The result is very often, well, testing positive for a banned substance. Now, as Ayesha is going to explain, while this does count for the majority of doping cases, there are 10 additional conducts that can also be considered doping. In other words, an anti-doping rule violation. We're going to share what those 11 are in just a moment. And then we're going to tackle the questions that you submitted in advance. And before we look at your questions, let's have a short introduction to the topic from Ayesha. Thanks, Ayesha. Over to you.
Thank you, Mary, and good afternoon to everybody who's joining us again. I've been asked to keep it really short on a general presentation on anti-doping rule violations to keep maximum time to answer your questions or answers, but I could have spent the next hours just discussing these 11 anti-doping rule violations. But you can all see them on your screen. You have presence, use, evasion, and whereabout failures. These anti-doping rule violations are applicable only to athletes, while all the others you see, be it tampering, prohibited association, administration, trafficking, complicity, these anti-doping rule violations can be committed either by athletes or athlete support personnel, such as coaches, doctors, administrators, and other support staff. So I will look into these 11 anti-doping rule violations in more detail as I'm answering your questions. But for the introduction, I wanted to spend a few minutes discussing the presence violation, because as Mary said, this is the most this is the anti-doping rule violation which is most abused, where we have the most amount of cases, and also 2.3, which is evasion or refusals, because we really feel that this is a very avoidable anti-doping rule violation. And if athletes understood it better, perhaps they could prevent this ADRV from occurring. So I directly move on to 2.1, which is presence of a prohibited substance in an athlete sample. This is most commonly known as a positive case. If you could just go to the previous slide, that would be great. We're talking about 2.1 presence. So this is what is just called a positive test, a positive case. And it's the one rule that is most associated with doping, and with good reason. It is the most common. 80% or even more of all anti-doping rule violations are presence ADRVs. So just a few tips and tricks, or few important things about a presence violation that I think it's imperative for athletes, doctors, coaches, and administrators to keep in mind. Firstly, every substance on the WADA prohibited list is banned. This includes substances with similar chemical structure or similar biological effect, even if it's not specifically named. The prohibited list is a live document, so it's updated every year. So really be vigilant about any new substance that might be added to this WADA prohibited list. Most substances on the WADA prohibited list are what we called non-threshold substance. So what does that mean? Because of course, very often we get caught in the legalese, but that means that no matter how much or how little of the substance is detected in the urine, it can still constitute an anti-doping rule violation. So it's not a defense to say, hey, I just had a few picograms or nanograms or micrograms. It does not matter. And one of the most fundamental principles of anti-doping is that the WADA code has a strict liability principle. This means that at the moment a prohibited substance is detected, it constitutes an anti-doping rule violation, of course, unless there is a therapeutic use exemption or a medical exemption. So what does strict liability mean? Because a lot of people, you go on hearing this word strict liability very often. So what it means that it is not necessary to show that the athlete had intent, or was at fault, or was negligent, or knowingly used the prohibited substance for it to constitute an anti-doping rule violation for presence. So once an ADRV for presence is established, it's then up to an athlete to explain how the prohibited substance entered his system. And that's what we call what was the source of the prohibited substance. And this is really the most important point that we look at while prosecuting cases. And mere speculation is insufficient. And you can't say, I think it came from a supplement. It may have come from a tablet. An athlete needs to conclusively demonstrate that a particular supplement, medication, or other product that he did use did in fact contain the substance in question. So that is a very quick summary of 2.1 presence of a prohibited substance. And now we'll move on to Article 2.3, which is evading, refusing, or failing to submit to sample collection. And I go on saying this is an avoidable anti-doping rule violation because it's extremely important for athletes to know that you can be tested anytime and anywhere by either your international federation or by your national anti-doping organization. It's a misnomer. It's incorrect that only RTP athletes are tested. It's incorrect that you'll only be tested during a dedicated 1 hour during the day. You can be asked to submit a sample collection at any point. And once you are notified, validly notified by a doping control officer that you have been selected for testing, there is a requirement on an athlete to submit to testing then and there. You cannot evade it, you can't refuse to provide a sample, and you can't fail to provide a sample unless there is something called compelling justifications. Now, of course, the natural next question that Mary might ask is, what is compelling justifications? And what I can tell you is that compelling justifications is very, very narrowly interpreted, and it's for every court and every tribunal to decide what is compelling justifications. But what I can tell you is what is not compelling justifications. So what I can tell you is these are the excuses that you cannot use to evade a sample. So it's not accepted as a defense to say, I had to go to church, I had a doctor's appointment, I had to go to school, I did not know that I was required to give the sample, I'm available to be tested later in the day, a few hours later, or my coach told me not to give the sample. Another athlete told me not to give a sample. I had to go out for dinner. I had to go for a movie. None of these are acceptable defenses. So the rule remains, and this is perhaps quite a technical point, that if it's physically possible to give a sample, if it's hygienically possible to give a sample, and if it's morally possible to give a sample, then the sample must be provided. So therefore, this is an avoidable anti-doping rule violation, and athletes can prevent being sanctioned for up to 4 years if they simply provide a sample as soon as they are notified to do so by a doping control officer. So, Mary, that's really a very, very high level and quick overview of 2.1 and 2.3 ADRVs. If you have questions from this, I think we'd take it at the end. But I think we could proceed to answering the questions that were submitted during the registration.
Fabulous. Thanks so much, Ayesha. And I will not ask my follow-up one then. What could be considered as compelling justification? As you very rightly said, that may well have been one of my follow-ups, and you've already tackled that there. So yes, on to the questions that everyone in the audience submitted. Now, we did receive a lot of questions, so thank you so much for all of these. In some cases, we have kept the question exactly word for word. In others, where we received some that were very similar to others, we have sort of made them a little bit more general so we can tackle them from many different aspects. I should also just once again underline that any questions that were outside the scope of today's topic, ADRVs, we will not be able to address today. But please do look out for future upcoming webinars with experts in other areas of anti-doping as well. And of course, as you will also understand, we are not able to answer any questions on individual cases which are either ongoing or concluded. We can't comment on specifics, but we can instead answer on general principles. So let's take a look at the first group, the first category of questions that you submitted. Very high level here, Ayesha. I've simply called these rules. We have quite diverse questions related to the rules, and we're going to tackle 4 under this first category. So back over to you for the first one, which is, what are responsibilities of sport entities, so clubs, federations, and so on, in case of anti-doping rule violations by their members?
It's been years of being on Zoom and I still don't unmute on time. Thank you, Mary, and it's really heartwarming to see these specific questions that the audience has asked, because it of course shows the athlete and ASP's interest in understanding more about anti-doping rule violations. So I'm very happy to answer them. So just starting with the first question, what are the responsibilities of sports entities? So what should clubs and federations, and I'm assuming the administrators out there do? So the first point would be knowledgeable of the rules, and you yourself need to abide by the rules. And of course, that's easier said than done. And I recognize that the WADA code is, 176 pages with many standards, many technical documents. But if you were just to look at Article 21 of the code, it really gives out what are rules and responsibilities of athlete support personnel. So the first one would be knowledgeable of the anti-doping rules and abide with the rules yourself. The second one, and perhaps the most important, is cooperate with anti-doping organizations when asked, cooperate with national anti-doping organizations, international federations, both during the testing program and even more so during investigations. So if an IF, if a NADO goes to a sports entity and asks to collaborate, share information, be proactive about it. So cooperate with ADOs. And the third, and again, the most important, because we understand that you have the closest link with the athletes. So use your positive influence on athletes' values and behaviors to foster anti-doping attitudes and to foster good anti-doping attitudes between athletes. So teach them to be diligent, teach them to provide information on their whereabouts, encourage them to check their supplements. So more your role is supportive both to athletes and supportive both to anti-doping organizations when it comes to investigating ADRVs.
Thanks,
That's it.
Ayesha. We've gone from quite a broad question. The next one that everyone can see on screen here is really quite specific. And the question is how to deal with countries that have high levels of clenbuterol in their meat. Now, there might be some people listening who don't know what this question might mean. And I know, Ayesha, you're going to tackle that. But very simply, clenbuterol is a substance prohibited in sports, but can be found in some aspects of farming. So over to you for a more detailed answer.
Thank you, Mary. And to continue exactly from where you said, clenbuterol is an anabolic agent, and in some cattle industry, it is given to cows as well as to pigs to bulk them up, so to increase their muscle mass. So sometimes if athletes are to eat a product or to eat a piece of meat that has been bulked with this steroid by the cattle industry, it could result in a positive test. And I believe that's where the question is coming from. So what should athletes do in such circumstances? I think that the comfort that athletes should get, and this is something that I want to stress on throughout this presentation, is that the WADA code and the guidelines it's a very reactive system of law, and it's a system that's constantly adapting and constantly changing based on scientific data and based on what is actually happening around the world. So when it comes to meat contamination, WADA has specific guidelines. So it says that for findings with substances that are known to be in meat, for example, clenbuterol, but you also have others such as zilpaterol, if it's up to a particular threshold, and I'll be a bit slow out here because here's when it gets a bit legalese. Athletes are given the opportunity to establish that the presence of that steroid is through consumption of contaminated meat. So if you have a analytical finding for clenbuterol up to a certain threshold in nanograms, the anti-doping organization will write to you and say, hey, you have a positive test. Can you explain whether or not you have been to a country, to a particular country where steroids are injected in the cattle? So if an athlete is able to establish this, the case is not taken forward as an anti-doping rule violation, and there are no consequences that are imposed on athletes. So to get more specific to this question, that was just a general overview on how WADA rules and guidelines adapt, taking into consideration pharma practices. By pharma, I mean the farming industry, not pharmaceuticals. So if you are an athlete and you're training, living, or competing in one of these three countries, and today the guideline really limits it to three countries, that is China, Guatemala, and Mexico. Of course, it's always better to eat in restaurants that can give you a guarantee on how that meat is sourced. Of course, if that's not possible and if you feel comfortable doing so, the advice would be to skip eating meat or be very cautious when you're consuming meat in these countries. Again, I understand that it may not be feasible in certain circumstances. So the advice is document and document all the meat that you're eating. Keep with you photographs of the meat, keep with you restaurants receipts, anything that can be submitted as evidence. But also keep in mind the trust in the system. So if you have eaten meat in a contaminated country, your anti-doping organization would just ask you to explain what happened. And if you can establish that it's come from contaminated meat, if you can conclusively establish on a balance of probability standard, there may not be any sanction that an athlete would be facing. So the system takes into account practices of various farming industries.
Thanks, Ayesha. Let's go straight on to the next one, which is a question about medications. And the question is, if an athlete has taken medication all of his or her life and found out that certain substances in the medication have been banned. So I guess the follow-up to that is then what happens? What should an athlete do?
So yes, I think the message to athletes is, it is a strict liability system. So as an athlete, it is your responsibility to know what is on the WADA prohibited list. And it's your responsibility to know whether or not a particular medication that you're taking contains a prohibited substance. There are resources on how you can do it. There are websites that you can check your medications on. And I'm sure Mary, at the end of the presentation, would give you these resources. We all live in digitalized worlds where we Google everything. So the advice is Google everything that you're taking, especially medications. Because medications can contain prohibited substances. Therefore, as athletes, you need to be on extra high alert that a medication can contain something prohibited. I think the second advice, or rather the second point, would be communicate, speak to your doctor, speak to your coaches, tell your doctors that you are an athlete, you have anti-doping obligations, share with your doctors the WADA prohibited list, and tell them that there are certain medications that you cannot take because they have been banned by the WADA prohibited list. If there is an alternative to taking these medications. So if you can take a similar medication that does not have a prohibited substance, that's of course preferable. If not, and again, this is not medical advice, we always say you need to apply for a therapeutic use exemption before you start using the medication. And that's very important. There would be a team of doctors who will evaluate the application and give you a response on whether or not you can continue to use this medication. I think when it comes to new substances that are added on the prohibited list, uh, keep in mind that the list is released on 1st October every year, but it in fact comes into force on 1st January of every year. So it's for this reason, because athletes are given 3 months of time to read the list, to understand it. WADA also has a document that shows the summary of main modifications or just details on what has changed. But you do have 3 months then to adapt, change your medication, and ensure that it does not contain anything prohibited.
Thanks, Ayesha. And as you mentioned, yes, we do have a slide of resources towards the end of this webinar, and we are going to be sending out the slides at the end too. So you'll be able to click on all those links to find out more information on many of the topics we have covered today. Now, the last one here, Ayesha, that's associated with rules. I think we can answer this one fairly quickly. It's quite a long question, but it has a reasonably short answer. And that is, can an accused athlete be punished under local government rules when the punishment is announced in an international forum?
I'll keep the answer short, and the answer really is it depends. So, of course, in some countries, anti-doping can also be a criminal offense. These are in very limited countries, very, very specific circumstances. This is the exception. This is not a norm. But these processes happen in parallel. The burdens of proof under criminal law and anti-doping law are completely different. Very often, the outcomes do not impact one another, and they're completely different violations. So the answer is yes, but very, very, very limited circumstances.
Thanks, Ayesha. We can move on to our second topic of the day now. Thank you. And I've grouped this one under process. Now, although there are 5 questions on this one, the first 3 are all related to samples here. So this is athlete samples that we are talking about. And I think the first one in particular, Ayesha, is a pretty short answer, just like with the last question. This question, though, is if the sample B result is the same as the sample A result and is positive, can the sample be tested again?
Perhaps I answer all 3 questions at the same time, because we're just talking about, in general, B sample results. So no, if a B sample result is the same as the A sample, it cannot be tested again. And why do we say you cannot choose a different laboratory to open sample B? I think the messages, or what we would want the audience to understand, is that to be a WADA accredited laboratory, these laboratories have to go through an extremely difficult and rigorous ISO accreditation process before they receive the status of a WADA accredited laboratory. These are state-of-the-art laboratories in a very extremely regulated system. You have the International Standards of Laboratories that is very detailed and regulates what laboratories can or cannot do. So therefore, there is absolutely no reason to have the B sample tested in a different laboratory. But that being said, athletes can still apply to WADA and request that the B sample is analyzed in a different laboratory. But you need to give your reasons. You really need to show why you want to go ahead with this request. These requests are then evaluated by WADA, and in extremely rare cases, extremely exceptional circumstances, WADA may instruct that the B sample process should be analyzed elsewhere. But I do need to emphasize is that this is the exception. This is not the rule. This is not the norm. And the third question is, how long does it take for a sample to be analyzed? In general, 20 days from the date the laboratory receives it, not from the date the athlete gives the sample. Given takes a longer time depending on whether additional analysis is required.
Thanks, Ayesha. And just a quick follow-up to the third question there. Athletes will, of course, be notified if they have a positive result, right?
Absolutely. Athletes would be notified by the testing authority of the sample. So therefore, we always say no news is good news. So if you've not heard from an anti-doping organization, in general, at least from the legal department, in general, that is good news.
Thanks so much, Ayesha. Okay, moving on to different topic now, but still under the process group. The next question we have on the screen here is, should NADOs, so that's National Anti-Doping Organizations, or WADA, have to establish an ADRV mirroring traditional justice system of innocent until proven guilty? Thanks for this one, Ayesha.
It's directly onto the hard questions. Well, I think this is a bit misunderstood by society in general, because anti-doping organizations do have the burden of first establishing that an ADRV has occurred, and then the burden of proof shifts to an athlete to explain what happened, to explain what is the source. So yes, the burden is still first on the anti-doping organization, be it an international federation or the NADO, to establish the occurrence of an ADRV. So it's a bit incorrect to say that it does not mirror the traditional justice system. But perhaps the misunderstanding is because in a presence violation, in the 2.1 violation, the ADRV is established by the scientific analysis. By that, I mean when a laboratory analyzes the sample, that is what establishes that the violation has occurred. And there is a strict liability imposed on athletes, as we just spoke, that they are responsible for what they consume and what is detected in their body. So therefore, this gives the impression, if you look at the fact that there's an analytical result that helps establish the ADRV, coupled with the strict liability that is imposed on athletes of their responsibility for what they consumed, this gives the impression that the burden of proof is reversed to establish the ADRV, but that's not accurate. Because also that you can get clarity when you look at any other non-analytical violation, such as a refusal case under 2.3, a tampering case under 2.5, or a whereabouts failure under 2.4. In all cases similar to presence, it is still for the anti-doping organization to establish that the violation occurred. And in fact, it's on a higher burden of proof. So for an anti-doping organization needs to establish on what is called a comfortable satisfaction standard.
Thanks, Ayesha. Now, you referenced 2.4 as part of your answer there, and that really relates quite nicely to the next question, which is about whereabouts. And before I read the question out, I'll just briefly mention that whereabouts here relates to athletes in what is called a registered testing pool, well, the whereabouts failures in particular, refers to them. And this is a group of athletes who have to provide their location for no advance notice testing. The other thing I would like to point out on the screen there is DCO, here stands for Doping Control Officer. So the question here is, what are other ways to start a whereabouts failure investigation without a DCO report?
Well, a DCO report, and I'll keep this answer quite short. I say that for every answer, and then I speak for 2 minutes straight. But a DCO report is more often than not, the starting point of a whereabout failure investigation. That being said, we often also rely on the information that is provided by athletes on ADAMS. And ADAMS is the Anti-Doping Administration and Management System. Don't quote me on that acronym. I might be wrong, but it's basically the platform of WADA where you submit your whereabouts information. So let me give an example. So if an athlete writes on ADAMS that she is in Italy, but then posts on social media saying that, hey, right now I'm currently in Switzerland, that is, of course, inaccurate information. So depending on the circumstances, that may be considered as a filing failure. So DCO report 95% of the time is the start of a whereabouts failure investigation, but other times we do rely on information that has been provided by athletes in ADAMS.
Thanks, Ayesha. And yes, we do have some really good questions that have come in the Q&A box live as we are speaking. We have 3 more slides of pre-submitted audience questions to go to. Some are a little bit longer than others. As you mentioned, Ayesha, I think for each of those, we could spend quite a lot of time talking about many of them. We're trying to give you as much information as we can in quite a short period of time. And the next topic that we'd like to have a look at are questions that have been submitted related to appeals. So let's just go straight into the first one, Ayesha. What is the correct way to appeal a punishment for unintentional doping?
Let's talk about how do you appeal a sanction. So a case can be concluded either through an agreement on consequences, where an athlete agrees with the anti-doping organization on what should be the applicable period of ineligibility, or a sanctioning decision, or you go in first instance before a adjudicatory body. This could either be the Court of Arbitration of Sport Anti-Doping Division or any other tribunal. So once these first instance processes are complete, the athlete, but often the NADO, the IF, and WADA have the right to appeal. Appeal is generally at the Court of Arbitration for Sport or at the national appellate body of every country. But this often depends on the level of the athlete, whether you're a national level athlete, whether you're an international level athlete. So the message is that all information on the timelines of appeal, the forum of appeal, when you can appeal, how you can appeal is provided in the rules. So feel free to reach out to the ITA, to reach out to your respective international federations or NADOs and ask for this information on timelines and forums of appeal.
Thanks, Ayesha. The next one we were talking earlier really straddles both legal and intelligence and investigations, and it's great to have your perspective on this one too. And the question is, if an athlete is falsely accused of doping, what legal and procedural support does the ITA offer to ensure a fair investigation?
Okay, so let's just get to the process of what the Intelligence and Investigation Department does when they receive a report saying that an athlete is doping, and how that eventually interplays with the legal process. So our INI department, the minute they get a report through Reveal or through any of their other confidential channels, this will prompt a thorough investigation on their end. Be assured that all leads are followed up. There is further investigative efforts done. There's further analytical work done, the details of which I do not have the privilege to discuss. So of course, it's only after this thorough investigation, if the INI team is prima facie satisfied that an ADRV has been committed, that they will inform the legal department of a potential anti-doping rule violation. Keep in mind that it's a potential violation. And receiving this information from INI does not automatically mean that the legal team will start drafting up a notification and notifying athletes. No, we will evaluate the evidence. We ask for additional information if needed. We conduct more interviews if it's necessary. And we determine whether this comfortable satisfaction standard has been fulfilled. As I said a minute ago, the burden of proof is still on the anti-doping organization to establish that the ADRV occurred. Comfortable satisfaction is quite a high threshold. So athletes are never notified until every suspicion of doping has been thoroughly investigated. And even once an apparent ADRV notification is sent out, athletes are given the full opportunity to provide their defense, to provide explanations, and each explanation is meticulously reviewed to determine whether an ADRV should be asserted or not.
Thank you so much, Ayesha. We can move on to our next topic now, which is consequences. And although there are only 3 questions here, we did receive a lot of similar questions about consequences. So it is worth us spending a little bit of time, Ayesha, I think, on each of those in turn. The first one being, what rule violations and consequences are relevant for support staff? An example here being given as a doctor.
Um, for once, I have a one-word answer, that is all. I think this was very much my first answer of the day, where we say that as doctors, as coaches, it's also your responsibility to ensure that athletes don't commit anti-doping rule violations. So it's a responsibility to say that these presence and use violations, that's 2.1, 2.2, are not committed by the athletes who you are advising and giving medical advice to. So these two are relevant for the athletes you supervise, but also personally for doctors, personally for athlete support personnel, you can also commit violations. These would be tampering violations, possession of a prohibited substance, administration, complicity. Again, I just started by saying that 4 anti-doping rule violations are only committed by athletes, and 7 can also be committed by support staff such as doctors. So all anti-doping rule violations are relevant for doctors, some from the perspective of looking after your patients who are the athletes, and others personally.
Thanks, Ayesha. And then the next one is very broad as well, but what are the consequences of unintentional doping? And I think here as well, you're also going to talk about the word unintentional as well as used in this question.
Okay, I think unintentional doping, there's a lot of misinformation that's going around, and it's often misunderstood. And I think that I'm going to be quite slow out here, and I take both the questions really together to say that intent, or what is understood as intent under anti-doping regulations, is not the same as intent as understood by a layman when it's your and my understanding of what is intent. Now, I'm limiting my answer to a presence violation, and how is intent defined when it comes to presence of a prohibited substance. And the word intentional, which is used in this article of presence, and I'm not going to give the article number, but it really means understanding the risks of your actions. So intent under Article 10.2 includes reckless conduct and includes negligent conduct in the definition of intent. So that's why we say that if an athlete blindly takes a medication without considering the risk that it may contain a prohibited substance, if this reckless and negligent conduct can be considered as an intentional violation under Article 10.2.3, of course, depending on the specific facts and circumstances. I'm giving a general overview, and it's not tailor-made to specific cases. So going ahead, I think some violations are presumed to be intentional. For example, if you have presence of a steroid in your sample, and for some, it is for the anti-doping organization to establish that the anti-doping rule violation was intentional. An example of that would be complicity violation. Now, an athlete can always prove that an ADRV was intentional and was unintentional, my apologies. And most often for presence violations, this is by proving source of the prohibited substance in your body. So how did the prohibited substance enter your body and result in the positive finding? That is the starting point most often to establish an unintentional violation. And of course, if you can conclusively establish that the ADRV is from a contaminated supplement, from environment contamination, from a pharmaceutical product, non-declared, all these scenarios may, depending on specific facts and circumstances, may be considered as unintentional violations and have a reduced period of ineligibility. So the message is intent as understood in anti-doping regulations is not the same as intent when we talk in common parlance.
Thank you, Ayesha, for being able to talk through both of those questions, which are, can have very, very detailed answers, and being able to provide, a summary in the space of a couple of minutes there. The last question here is about minimum and maximum sanctions. As I mentioned, we had quite a few sort of similar questions. Things like which sanction has the most penalties, what happens about sanctions after a second ADRV. And I think all those types of questions can be summarized by the one that we've put on screen there. So maybe you can tackle this one for us next.
Okay. So a sanction is a range. It's not a fixed number. And the VADA code, it provides a process for which sanctions can be increased or decreased. Now, what is the applicable sanction for an anti-doping rule violation generally depends on three things. Firstly, the type of ADRV. So if you have a presence violation, whether that's a specified or a non-specified substance, whether it's a tampering violation, whether it's another violation. The second point would be, is this your first violation, or are you a repeated offender? Of course, if you're a repeated offender, it's a larger sanction that is going to be imposed. And third is, who is committing the violation? And I'm speaking very, very broadly, but anti-doping rule violations committed by athlete support personnel sometimes tend to have longer period of ineligibility. So sanctions are a range. They can go anywhere from a warning to a lifetime period of ineligibility and everything in between. So what the code does, it sets a starting point for the sanction, and then it explains how can the sanction be increased or how can it be mitigated. So for example, let's say an athlete tests positive for an anabolic steroid. So the code says the starting point of this sanction is 4 years. It can be increased in some circumstances, and it can be reduced or mitigated in some circumstances. So, of course, if an athlete can conclusively prove that this positive is from contamination, it's from supplements, it may, depending on the circumstances, mitigate the sanction. But what is really important is an athlete needs to give actual evidence. You need to identify the product, the medication, or the supplement that contain the prohibited substance. You cannot speculate on it. So if you say, I think it's come from a supplement, I think it came while I was in the gym, that is insufficient to reduce or to mitigate the sanction. You need to be able to you need to be able to give conclusive evidence on this point. So sanction is a range, it's not a fixed number.
Thanks, Ayesha. We just have one more slide with two questions on it before we go to the live questions. And these are quite varied, these two questions here as well. First one, though, is could you comment on the case of the 23 Chinese swimmers in light of the strict liability rule in doping cases?
Well, I see this question was also submitted in the question and answer box, so I'm happy to answer it. And I think that we do clarify that the ITA was not responsible for handling the case of the 23 Chinese swimmers because this was prior to the delegation of the results management to the ITA. We believe that WADA has answered all questions on this case. There has been a lot of public discourse on this matter. There are several press conferences. There's a full report by an independent prosecutor. So all information on these cases is publicly available for anyone to read. I think the crux of these cases is environment contamination, or rather it's contamination, which I have touched upon earlier today, to say that if athletes are able to prove, and I'm talking again in general and not specific to these cases, but if athletes are able to prove the environment contamination or prove that contamination occurred on a balance of probability standard by giving actual evidence, that does impact the sanction, which, as I said, is a range and not a fixed number. What I do want to say and the message to give is that anti-doping is a system that constantly evolves and adapts. The WADA code changes every 7 years. It's a very reactive system that's willing to learn, willing to change its rules, and really reflect the learnings that data and science can provide. And we need to recognize this as a very positive part of the system. And let's take, for example, something I've already spoken about, which is meat contamination. So 10 years ago, if an athlete tested positive for clenbuterol, that could be a sanction from 2 to 4 years. But once data and science could comfortably recognize, once the research was done, that yes, clenbuterol is used as a bulking agent in the cattle industry, the WADA rules were amended to reflect this change. So today we know that below a certain threshold, clenbuterol is reported as an atypical finding, and potentially there's a no ADRV and no consequences, no sanction. So Again, when it comes to environment contamination, pharmaceutical contamination, or any kind of contamination, if data is out there and if the science can show similar to meet that how the problem exists and where it does, the WADA Code 2027 version, but also the rules are constantly amended and adapted to reflect learnings of data and science.
Thanks, Ayesha. And the final ones of the pre-submitted questions. How do you deal with the problems of the medication that athletes take? How do you know the line between medication and doping?
I'm cognizant of the time and my apologies. I went so into details, but it was important to address some questions. So I think athletes who are given a therapeutic use exemption for a prohibited substance are given this exemption only after a thorough review of the medical documentation by a team of healthcare professionals who form a part of the therapeutic use exemption committee. So there are clear guidelines developed by WADA on when a TUE is to be granted. And this committee of TUE experts takes into account several factors such as, is there any alternative medication? Or whether the therapeutic use of the substance can produce any additional enhancement of performance by the athlete. So, in other words, would the use of the medication give the athlete an enhanced performance? So it's only after this detailed review is a TUE even granted to an athlete. There's a case-by-case assessment. The entire medical case file is assessed before a TUE is granted.
Thanks so much, Ayesha. I'm going to show you one slide here. This is what you are going to receive after the webinar ends, but with additional resources on many of those topics that we have covered today, both from a legal perspective, but also from an education perspective as well. So Ayesha, let's take a look at the Q&A box and let's see how many of these we can get through. As you mentioned, we've probably covered maybe number 2 and 3 that's already in the box there. But the first one, I think is an interesting one to tackle, and that is, in case an athlete helps or provides assistance to another sanctioned athlete, for example, sparring, which rule violation occurred? None?
I'm sorry, I cannot find the question, but
You
perhaps can you repeat it? Because what I see on my screen is different, and I'm happy to address the questions I see on my screen first.
Sure, of
Okay,
course.
so I think there's a question on an adverse analytical finding for dorzolamide, and it says that should you
Mhm.
ask for the specific concentration for the laboratory? Um, well, I think dorzolamide, we always ask for every substance. We ask the laboratory to provide us with the roughly estimated concentration. And dorzolamide is a substance that is not prohibited when it is used through a topical ophthalmic route. That means that if it's used as eye drops, it is permitted and it does not constitute an anti-doping rule violation. So in our practice, if you would get a positive for dorzolamide, we would ask the laboratory to provide us with the concentration, and we would also give the athlete the opportunity to explain whether they ever used eye drops containing dorzolamide. So it's yet another example of where the system takes care of athletes, keeping in mind the nuances of substances.
Thanks, Aisha. I'm not sure which questions you can see, so maybe you can tell me
Yeah.
the next one that you see and we can
Okay.
go in that order.
Um, I think there's one question that it's I'm sorry about that. Presence of a substance while your answer regarding clenbuterol in meat, you mentioned that levels matter. And I think it's important to clarify this point, so I'll quickly take it. So most substances are non-threshold substances. So absolutely any amount of a steroid in your body is an anti-doping rule violation, be it 2 picograms, be it 100 micrograms. But when WADA develops guidelines for certain substances, they put thresholds in it. So for example, with meat contamination, they've put a threshold to say that if you have a positive up to this threshold, and you can explain that it came through consumption of contaminated meat, it would not be an anti-doping rule violation. So general rule, there are no threshold. Certain substances in certain categories, in certain circumstances, do have a threshold.
Thank you, Ayesha. Let's tackle one more, and then I'll maybe invite those people who have submitted questions that we haven't had time for today to email us, and we'll put our email address up in a couple of minutes. What other questions can you see there?
I can see if an athlete helps or provide assistance to another sanctioned athlete, which rule is violated? I must say I'm not sure I understand the question, but I think it's important to know that like prohibited association is also an anti-doping rule violation. And I always keep my copy of the WADA code with me for these very instances. So you have Article 2.10. And if I have a minute to open it, it says that association by an athlete in a professional capacity may lead to an anti-doping rule violation. So if you know an athlete is sanctioned, even if you are not sanctioned, you competing or you training with a sanctioned athlete may lead to consequences against you.
Thanks, Ayesha. And I think that is what they're referring to here. They're talking about sparring, so in a training situation. Um, Ayesha, thank you so much, as always, for all your knowledge. It's such a huge topic, and the way you're able to answer so many questions on a huge range of these subcategories has been really fantastic. As I mentioned, I can see maybe 3 or 4 questions that we didn't get a chance to tackle live. So please do get in touch with us if you would like an answer. You can reach us at any time at education@ita.sport. And that leaves me to say, Ayesha, thank you again so much for your participation in this webinar. A big thanks to our audience for participating in such big numbers as well. We hope you found this session valuable. Hopefully see you all again soon at our next monthly webinar, and have a great rest of the week. Thank you all. Bye-bye.
Thank you.